everyone, today's topic is about law of contract. There are three topics covered in law of contract. The first one is definition of law of contract. The second is types of law of contract. And the third is classification of law of contract. Are you ready? Let's get started. Let us start with the introduction. Contracts play a significant role in contemporary society, serving as the essential pillars that regulate numerous transactions and interaction across personal and commercial domains. Furthermore, the law of contract, which is a fundamental aspect of legal system throughout, establishes the structure through which these agreements are established, carried out, and upheld. Last but not least, contract law fundamentally comprises a collection of regulations and principles that serve to guarantee the legal validity and enforceability of agreements entered into by parties.
One might ask, what is law of contract? One might ask, what is law of contract? Now, a contract is a legally recognized agreement that establishes rights and obligations between the involved parties. In essence, a contract can be characterized as a legally binding agreement that is enforceable by the law. Although agreements form the foundation of contracts, it is important to note that not all agreements give the rise to legal obligations, and therefore, not all agreements can be classified as contracts. In other words, the legal doctrine of contract exclusively pertains to agreements in which the involved parties possess the intention to establish legally binding relations. However, the matter at hand pertains to a legal inquiry.
Furthermore, what are the classifications of law of contract? Contract classification is a crucial component of legal practice. Contracts are the legal framework that governs all commercial transactions, from simple purchases to intricate business deals. Contract could be classified into two categories, such as written law and unwritten law. Written law is referred to the body of laws that's enacted and codified by legislative authorities. It consists of statutes, regulations, and ordinances created by Malaysian Parliament and state legislatures. The most important piece of written law in Malaysia is the Federal Constitution, which is the supreme law of the land. Other written laws include various acts of Parliament, such as Contract Act 1950 and the Sale of Goods Act 1957, which govern contract law among other legal matters. Next, unwritten law. Known as the customary law or common law, is not enacted by legislative bodies but is derived from judicial decisions and customary practices. In Malaysia, it largely follows the English common law system. Common law is based on precedents set by previous court decisions, and judges often refer to these precedents when deciding cases. Customary law, on the other hand, is based on the customs and traditions of indigenous people in Malaysia, particularly in matters related to land and nature. Moreover, what is written law in contract law? The main piece of legislation governing contracts in Malaysia is the Contract Act 1950. It lays out guidelines for the creation, fulfillment, and enforcement of contract. For example, the Sale of Goods Act of 1957. This law focuses on agreements pertaining to the sale of goods and their warranties. Next, the Specific Relief Act of 1950, which discusses remedies like specific performance and injunctions that may be available in the event of a contract breach. Besides, Civil Law Act 1956. This act incorporates English common law principles into Malaysian contract law, including the concept of precedent and doctrines like frustration of contracts. In addition, Electronic Commerce Act 2006. This law addresses contracts formed electronically and provides legal recognition to electronic contracts and signatures. Last but not least, Consumer Protection Act 1999. It offers protection to consumers in contractual transactions and outlines various consumer rights and remedies in cases of unfair practice. An example of unwritten law that is used in contract law is common law. In Malaysia, the common law principles derived from the English legal system continue to have a significant influence on contract law. Courts often refer to English common law decisions in the absence of specific statutory provisions. Next, equity. Principles of equity, such as specific performance and injunctions, are also applied by motion courts when appropriate. These principles supplement the written law and provide remedies that may not be explicitly mentioned in statutes. Also, it's important to note that Malaysia follows a dual legal system, where Islamic law, also known as Sharia law, plays a role in certain areas of contract law, particularly for contracts involving Muslims.
What are the types of law of contract?
Classification of law: enforceability, creation, performance.
Enforceability. To compel parties to a contract carry out their individual responsibilities and commitment as stated in the contract. It donates the contract's term and conditions are legally binding and may enforce in the court if one party doesn't uphold their end of obligation. When a contract is enforceable, both parties are legally obligated to carry out the terms of the agreement and there are legal resources available in the event of non-compliance. Enforceability. Valid contract, void contract, voidable contract, illegal contract, unenforceability contract. Valid contract. A contract considered valid if it satisfies all the requirements for being legally binding as outlined in Section 10 of the Contract Act. Namely, agreement is made by the free consent of parties competent to contract for lawful consideration with lawful object not expressly declared to be void. It is deemed to be a valid contract. Void contract. A void contract may initially be lawful but loses its validity when a certain event occurs. Often these contracts are usually illegal, impossible to perform, or against public policy, and have no legal effect. Contracts that are void from beginning and governed by Section 2 of the Contract Act 1950 as well. For instance, a contract to sell illegal drugs is void. Voidable contract. A contract is voidable if it is upheld by one of the parties, in which case other parties may cancel the agreement. As long as the parties who choose it is to reinforceable doesn't revoke it due to factors such as fraud, mispresentation, or coercion, such a contract is still effective. These are governed by Section 19 to 30 of Contract Act 1950. Contracts are those that involve unlawful object or purpose from the outset. These contracts are considered void ab initio, which means they are void from beginning and have no legal effect as in states in Section 24 of the Contract Act 1950. Legal contract. If any part of consideration for one or more object or any one or any part of any several consideration for a single object is unlawful agreement, is a void. This section essentially states that if any part of a contract involves an unlawful act or consideration, the entire contract is void. For instance, a contract is to engage in illegal gambling activities would be void under the prohibition.
Unenforceability contract. Contract that cannot be upheld in court because of certain technical issue, such as lack of writing, the passage of time, and the lack of stamp. The parties may carry out such contract, but the harmed party is not entitled to legal remedies in the event of contract violation or repudiation. They are not automatically void but cannot be enforced by a court of law. Unenforceability contract. Statutory provision that related to unenforceable contract in Malaysia include Section 10, 23 and 25 of the Contract Act 1950. Section 10 of the Contract Act 1950. All agreements are contract if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. This section outlines the basic requirement for a contract to be valid, emphasizing a lawful consideration and a lawful object, contract that lack this element may be unenforceable. Section 23 of the Contract Act 1950. The consideration or object of an agreement is lawful unless it is forbidden by law or such a nature that if permitted it will defeat the provision of any law, or is fraudulent, or involve or implies injury to the person or property of another, or the court regard it as immoral or opposed to the public policy. This section deals with consideration or object that are unlawful against public policy or otherwise unenforceable. Contract with such consideration or object may be deemed unenforceable by the court. Section 25 of the Contract Act 1950. Agreement without consideration void unless they are in writing and registered, or a promise to compensate for something done, or a promise to pay a debt barred by limitation law. Section 25 deal with agreement that lack consideration. Such agreements are generally unenforceable unless they fall within specific exception outlined in the section.
Curation. The process of creating a contract is called its formation. An offer, acceptance, consideration, legal capacity, and a lawful purpose are normally included in this process. Oral agreements are valid, but some contracts require more formality through written documents. There are two types that fall under the heading of curation. The first one is express contract, and the second one is implied contract. Express contract. It is a written or verbal express contract in which the term and conditions are clearly stated. Section 9 of the Contract Act 1950 covers express contracts. For instance, a written understanding between a landlord and tenant is described as a lease agreement. Implied contract. Even in the absence of an express agreement, contracts are implied by conduct and circumstances as addressed in Section 9A of the Contract Act 1950. The law implies that this is a requirement of fairness. In restaurants, for instance, placing an order creates an implied agreement that you will pay for the food.
Performance: the fulfillment of the commitment and promises made by the contract's parties is referred to as the performance of the agreement. It entails performing the obligations set forth in the contracts within the predetermined time frame and in accordance with the predetermined forms. The contract is deemed to have been executed, and the parties have completed their respective obligations when both parties comply with its requirements. Classification in performance such as executed contract, executory contract, bilateral contract, and unilateral contract. Executed contract. Fulfilled obligations and a completed contract mark and executed agreement. Suppose that a homeowner pays a contractor to renovate their home, and the contractor completes the renovation as specified in the contract. Section 2D of the Contract Act 1950 defines them as contracts whose purpose has been fulfilled. Executory contract. Executory contracts are those in which future performance is expected. A contract for the delivery of goods in the future, for instance, where the delivery has not yet occurred.
Under the law of contract, there are two types of contracts, namely bilateral contract and unilateral contract. Now, for the first one, which is bilateral contract, is the most typical arrangement in which both parties make promises to one another is a bilateral contract as outlined in Section 2, Paragraph H of the Contract Act 1950, and not to mention every promise is viewed as a consideration for every other promise. For instance, acquiring goods or services from a retailer constitutes a bilateral contract because it is a one-to-one agreement, and giving you the good in exchange for your promise to pay is what the contract is all about. Moving on, we have unilateral contract. Now, unilateral contracts are covered by Section 2, Paragraph F of the Contract Act 1950. It entails a promise from one party to take action if the other does something specific. Upon completion of the necessary action, the contract begins to take shape. For example, a business offers a reward for the information that results in the recovery of a lost item as a prime instance. The business is required to pay the reward if someone provides the information and the item is found.